I won't say anything about the normative complex in a global world, which is now coming to the violent stage, perhaps to the force, to its power play. I won't say very much about the subject because our speakers are more endowed to do so. I just let me give two remarks about the composition of our panel today, which has been, after the previous panels, composed, I suppose, not by accident, but par la force des choses, by two philosophers, one historian and one sociologist. We began with a theoretician of law, legal theory, criminal law, who has even published about culpability, Schuld, and the law, Professor Klaus Günther, whom I shall very briefly introduce, as I shall be very briefly also with our other paper givers in this panel. He is since 1989 professor of legal theory and criminal law and procedural law at Goethe Universität in Frankfurt Main, and what is not less important, he is one of the two directors of the so-called cluster of excellence, what is a very German expression, difficultly to translate, about the formative of the normative orders at the Johann Wolfgang Goethe University in Frankfurt. I won't say much about this. He has studied and also made his doctorate degree and his habilitation in Frankfurt am Main. Has been fellow at various important universities, from the Wissenschaftskolleg, the Berlin College for Advanced Studies, to the law school in Buffalo, to Corpus Christ College in Oxford, and à la Haute École des Hautes Études en Sciences Sociales, jusqu'à la LSE, London School of Economics. From his various publications, I will only give three titles who perhaps may give us the right or the wrong prejudices, but at least we have some of them. The one is Schuld und kommunikative Freiheit, communicative liberty and guilt, culpability. The other one is a book co-edited in the context, I suppose, of this excellent cluster. Law without state, question mark, normativity of law giving without in situations without state. And last but not least, eine Festschrift, also an untranslatable German terminus, für Jürgen Habermas on his 17th birthday. The publicity.
17th or 17th?
No, 17th, yes. Okay. 70, but on the public space or publicity of reason and the reason of the public space. So with this information and prejudices, I'm happy to give you the floor.
Yeah, thank you very much for this kind introduction, and thank you very much for giving me the opportunity to speak to you about a joint research project which has already some time ago begun and which is part of this research network in Frankfurt, Multi-normativity. And when Gebhardt suggested this title to me, and since I'm only on the periphery of this joint research project, it's mainly organized and driven by Thomas Duwe, Willow Schwedz, and Armin von Bogdandi, I thought, well, this would be an opportunity to really get into it and to prepare something which I then, after having discussed here, could discuss with my colleagues in Frankfurt. So it's really work in progress, different to the excellent contributions we had in the morning on consolidated knowledge and arguments. This is somehow a little bit shaky, so I have to apologize in advance. So the question, of course, is what is meant by multi-normativity, and perhaps to introduce this topic, I should start with legal pluralism, because multi-normativity is a kind of extension or a continuation of theories of legal pluralism, and the first part of my presentation will try to demonstrate that there are some conceptual reasons for making this shift from legal pluralism to multi-normativity. So some of the standard definitions of legal pluralism, take the two famous, most famous, from Griffiths and Sally Engel Mary, is an attribute of a social field and not of a law or of a legal system. A descriptive theory of legal pluralism deals with the fact that within any given field, law of various provenance may be operative. So legal pluralism is not an attribute of law itself, but of a social field on which law of various provenance may be operative, so that more than one legal order coexists. Similar definition by Engel Mary, a situation in which two or more legal systems coexist in the same social field. So the point of legal pluralism, at least according to these definitions, is that on a given social field there are coexisting different legal orders. So it's clear that these orders are legal. And the point of legal pluralism is, of course, to demonstrate that the idea that there's only one legal order, as in the modern nation state, or as is claimed for the modern nation state, that this is an illusion and a myth, because in fact, even in modern societies, not only in ancient societies, we can observe the fact that different legal orders coexist, that not only state law but other legal orders are operative there. But what seems to be no real problem or question is whether these orders are legal, whether they deserve the attribute to be legal orders. A slightly different definition by Paul Schiff-Berman, 2007 in his article on global legal pluralism, which then became part of this book, which was presented this morning. He starts to make a shift. He also starts with the common definitions, but then one can find another definition or description of legal pluralism when he says one can often observe that people feel ties to and act based on affiliations. People feel ties to and act based on affiliations with multiple communities in addition to their territorial ones. Such communities may be ethnic, religious, or epistemic, transnational, subnational, or international, and the norms asserted by such communities frequently challenge territorially based authority. So what is interesting in this definition is that there's no reference to the law. Only the assertion that there are multiple communities with different, let's say, identities or normative orders, ethnic, religious, epistemic, are related to different spaces, national, subnational, international, and that all these different affiliations to different communities challenge territorially based authority, so the traditional authority of the nation state and its normative order. So what one can observe, as I said, is that the question whether these communities and their normative orders are legal ones or not, it seems doesn't matter. It's only the observation that besides or beyond the nation-state normative order, there are many other communities with their own normative order. Now, of course, not only this kind of description, but already within the discourse of legal pluralism, there was already this question whether the definition of the legal pluralism does matter for legal pluralism or not. Whether this is a serious question, which whether one should deal with the concept of law and its possible definitions, or whether this question is somehow irrelevant to legal pluralism. So the question is whether there is a problem of definition in legal pluralism. One doctoral student in Frankfurt who just finished his dissertation on the right of legal pluralism asked the question, what is the legal in legal pluralism? Ralf Seinecke will be published next year, and I think it's one of the best books showing the development of the debate of legal pluralism. So the answer to this question, at least among recent authors like Schiff Berman or Tamanaha, is that this question doesn't matter to legal pluralism. So Schiff Berman, the whole debate about law versus non-law is largely irrelevant. And a step further moves Tamanaha when he says towards this question we should take a non-essentialist position. So there's no essentialist definition of the law. Can explain with certain conditions which have to be fulfilled in order for a phenomenon to become law. No, as one should take a non-essentialist position, treating as law that which people view as law. So it's radically subjectivist. Everybody who claims for his or her normative order to be law, then it counts for legal pluralists, it's law. Interesting question, which is not so relevant here, but what always bothers me is why then it is so important for the people to claim that their normative order is law. If it doesn't matter whether it's law or not, what is the surplus value of calling it, naming it law? Yeah, I think legal pluralists should at least think about that, why it's so important for people. There must be some attributes which make it preferable for members of a normative order to call it their normative order law. So if one takes this seriously, that definition doesn't really matter for legal pluralism, then I think it's one should draw the consequence and take another step. So if there is no problem of definition of law versus non-law, then one can easily take into account other types of normative orders, customs, cultural normative orders, religious, ethnic, economic, epistemic, all the list, all normative orders and communities which are on the list of Schiff Berman. And one then should take them into account as such, as economic, as religious normative orders, and not try to find out whether they are law or, as Schiff Berman says, quasi-law, like the communities and to which we belong and have affiliation to, and quarrel with the question whether they are law or quasi-law or non-law, but take them seriously as normative orders, different normative orders, and then focus on their interaction, overlap, collision, conflict with the normative order of law. And a further consequence would be to say that law itself then becomes one type of normative or normativity, among others. And I think that's the step towards multi-normativity, which I think is necessary if one takes legal pluralism seriously, that the definition whether a normative order is law or not doesn't matter. So that's just a natural consequence. But that's not the origin. I mean, that's my approach to multi-normativity, but I should be honest and say that multi-normativity is not an invention of mine, and that the history of the short, very short history of multi-normativity goes back to legal history. And the first one who coined the term is, oops, I have just this. There's one left, I guess. Okay, there's one slide left. Miloš Vec was the first one who coined that term, and he started from two different phenomena of normative orders. The first one he calls, or he takes the term Zeremonialwissenschaft, which is a strange, I think it's a kind of art. I don't think that it's a kind of science or something. I think it's a kind of art, how to organize a princely court in the Middle Ages and in the 16th, 17th century, because a princely court was a very complex and complicated normative system. And it was very, very important to pay different kinds of attention to the different statuses of the nobles at the princely court. So one could really make a big mistake if one did not offer a chair to someone, to a nobleman who deserved sitting on a chair, but to someone who did not deserve to sit on, but who had to stand when the prince, or to stand up when the prince entered the room of audiences in the court. So there was a whole normative system and a normative complex, and of course these rules and norms, it's difficult to tell whether they were legal or whether they were somehow conventional. Of course they were conventional, but in part they were legal. One could raise a claim and perhaps bring a claim in front of a court, but many of these rules were kind of, in the Hegelian term, Sittlichkeit of a princely court, which were customs, but serious customs, which one could not simply violate. This had complicated consequences. So this is Miloš Vec's first example of multi-normativity, because these are norms of different origins and different validity, different sources, some of them legal, but interacting with other norms of this community of noblemen at a princely court. The second example of Miloš Vec is in the 19th century. There started this development that together with industrialization, there was the necessity or the need to standardize until today. This is a need to standardize industrial products so that they fit to each other, that if you buy something in Great Britain, you can use it also in Germany, and so on. So this requires that there are some standards for how to design industrial products so that you can use them everywhere, or that you can organize a kind of economic exchange or communication on an international level. So one of these examples are the DIN norms for the, we know it from the shape of paper, or global communication like the Universal Postal Union 1847. So certain standards which many different nations who have their own legal order agreed to. And of course these technical standards were easy to agree on because they were not so politically contested. And one simply had to find a standard, and that's it. So there was no question of national identities, whether one should have the one or the other. And for Milosevic, that's one example of a kind of internationalization of law on a field which was not very much contested and therefore functioned quite well, although the 19th century also was the century of imperialism and aggressive nationalism. So this was the first step towards internationalization. But what is most important for Milosevic is that these technical standards were created by experts, not by lawyers, but by experts, technical experts, and then somehow gained a kind of validity, were valid norms which were used and could be practiced by the members, for example, of the Universal Postal Union. So these two examples are from Milosevic, the historical beginners of multi-normativity, and then he, in a presentation at the Berlin-Brandenburgische Akademie, he gave this definition that if one, I was unable to translate that, that multi-normativity we can observe now, starting in the 19th century, in the era of globalization, that laws interact with social rules, with duties of courtesy, like in the princely court in the 16th century, or with religious imperatives and technical standards, and all these are examples for different types of normativity which coexist and interact with each other and interact with the law, and that's for him the definition of multi-normativity. So that's the way how the term multi-normativity was coined. So now one can go back to the definitions of legal pluralism and just substitute for the term legal order normative order. So one can take Griffith's definition and just say multi-normativity is an attribute of a social field and not of a law or legal system. A descriptive theory of multi-normativity deals with the fact that within any given field, norms of various provenance may be operative. It is when a social field, in a social field, more than one source of norms, more than one normative order is observable, that the order of that field can be said to exhibit multi-normativity. And the same game one could play with Engel-Mary's definition. So that's the starting point of research on multi-normativity. But then, of course, one has again perhaps the problem of definition. But I thought that Thomas Duwe would be here, so that's a slide for him. Because in his article in Rechtsgeschichte in 2012, he speaks of polynormativity. I think that's only a variation of multi-normativity, that he says, well, we still have the problem how to define then legal normative orders from other types of normativity, and I would have liked to ask him whether he thinks that this is really a serious problem for research on multi-normativity, taking into account the way how legal pluralism dealt with this problem of definition. But what I'm in particular interested in, and that's a similar problem as in legal pluralism, is then the dynamics of multi-normativity. And of course, then the question is how to deal with a social field which can be said to exhibit multi-normativity. How should one conceive of these different normative orders? Are they monadic or incommensurable? Are there hierarchies among different normative orders? As we already heard in the last presentation, the nation state for a long time at least claimed to be the integrative normative order of all different kinds of normative orders within a society, or whether then in the era of globalization one should focus more or become more sensitive on transfer or translation relationships between normative orders, focus on the question whether one normative order is adopted or recognized by another. The traditional view of the state law that recognizes commercial customs, lex mercatoria as valid law, the phenomenon of the hybridity of normative orders, and of course then the conflict or collision between different normative orders. And the last one is the topic which interests me most. And I just want to present three models of conflict resolution among different normative orders. The one is, of course, the idea of an objective normative order which integrates all other normative orders. And this objectivity is founded or localized in a god or a sovereign state law, or some kind of universal normativity. Or the other, the extreme opposite of the first model would be what called Carl Schmitt in his essay on political romantics called occasionalism, so a balance by chance. Or the third one is what I would suggest, a kind of shared normativity among multiple normative orders. So the first one, of course, is an objective third position, which somehow then organizes the relationship between colliding or conflicting normative orders. And we already talked about that in the morning. Günther Teubner explicitly rejects the idea of a third position, but one should take into account that this is still a strong idea that a conflict between two conflicting parties should be resolved by someone who is in the position of a third. Alain Supiot, in his book on l'homme juridique some years ago, defended this idea of a third. Of course, he admits that this should not any longer be localized in a god or in a state, but that at least the socially effective fiction of a third position should still be accepted. Because otherwise, and that's a quote I find in John Locke, who said, without God, promises, covenants, and oaths, which are the bonds of human society, can have no hold upon an atheist. So therefore, atheists should be excluded, because one cannot make a contract with an atheist, because then there is no backing in a third position that guarantees the validity of a promise which I made with some supernatural punishment. And it's a position like Wotan in the Ring, in the third position with his spear having all these contracts on his weapon. One can find a similar interpretation of the third position in Savigny's lectures on methodology, where he said that the necessity of the state, is this third position, resolving conflicts between conflicting parties. And then he says, but the state again could be arbitrary, so we should take into account as this objective position of a third the Gesetz, the law. That's where objectivity is localized and founded. Of course, I mean, there's a whole bunch of critique of this kind of interpretation of the third as substance, essence, or objectivity. I leave that and change to the next position. Occasionalism in Carl Schmitt's critical interpretation of political romanticism. One can find, I think that's a nice sentence, because one can see how Carl Schmitt suffers from this loss of objectivity. When he says the romanticists, they are occasionalists because they live in a world without substance, without functional ties, without leadership, without any conclusion, without any definition, without any decision, without last court, infinite, only managed by the magic hand of choice. So that would be the other extreme position. We have all these conflicting, colliding normative orders, but they create their own world. They are incommensurable, and we can only hope that the magic hand of choice will somehow put them into a balance, otherwise there is no other possibility to find any position of a third or objectivity which would integrate them. Of course, as a radical opposite to this idea of objectivity, this is not a serious alternative, but one can see easily, at least through the glasses or spectacles of Carl Schmitt, how these two extremes are somehow complementary to each other. So I would like to opt for the third model, that's shared normativity. And it's a pity that Schiff Berman and Günther Teubner are not among us here anymore, because I think what they claim is something like this shared normativity. So, as Schiff Berman in the morning explained, this management of hybridity should be a way to bring multiple normative orders, not only legal orders, but multiple normative orders and communities in a dialogue in order to resolve conflicts. And if one has a closer look on the list, which there's another slide lacking, on the list that Schiff Berman proposes for this conflict resolution. So I just read it from his 2007 article. Says the actors, the participants in such a dialogue have to be at least be willing to take part in a common set of discursive forms, turning enemies of a normative conflict into adversaries, sharing a common symbolic space, requires participants to accept the principles underlying the values of procedural pluralism itself, wrestle explicitly with questions of multiple community affiliation, and take into consideration conflict values, and having strong normative statements about normative orders which deny fundamental principles and human rights. So if one takes this list seriously, then one could easily say, as we discussed in the morning, that there is something presupposed like a shared normativity among conflicting multiple normativities. And of course, this is not a third in this sense, like in the first model, like God or state, but it is still something to which conflicting parties have to refer to as something like a shared or common ground for resolving their conflicts. And the same, and I would have liked to ask Günther Teubner, but I can't do that in Frankfurt, what he thinks about my interpretation of these ideas in his recent book on Verfassungsfragmente. Of course, he starts with the Luhmannian idea that there's no system within a society which can represent the whole society as a whole. And he indicated that in the discussion this morning, that each social system or each regulatory regime has to create its own ordre public, transnational, from its own perspective. But,
sorry.
Okay.
So 3-4 Minuten.
Okay. So that in the end, and it works like the categorical imperative in Kant. So each participant in this conflict game has to generalize his or her maxim as if it were counterfactually something like a shared normativity, which could integrate the different conflicting normative orders. And I think that, I mean, taking into consideration, of course, all these functional differentiation and autopoietic closure of social systems, in order to resolve conflicts, they have at least counterfactually anticipate something like a shared normativity in order to resolve that conflict. And I think and that's what I would like to focus on then, is how to explain this shared normativity, which is always indicated. Schiff-Berman talks about common symbolic space. Teubner from counterfactual common Sinnhorizont, something like a common horizon of meaning which we share counterfactually. They are very, very cautious, and I would like to go a step further and to say, well, what's the content of this shared normativity? And my suggestion would be, of course, we have to presuppose responsible persons. Lon Fuller's legal morality or morality of law, the responsible person, which has to be presupposed in the project of submitting human behavior to norms and rules. It's the internal point of view, H.L.A. Hart's critical reflective attitude, which we take towards this shared normativity, because we could criticize each other when we violate this shared normativity. It's, of course, the shared normativity of communication, all these commitments, responsibilities of reasoning, which are recently made explicit by Robert Brandon. And it's a shared normativity of communication beyond particular communicative systems or communities and their normative orders. But of course, also beyond objectivity and substance. This is not a normativity which we could claim to be a god or a state. But yeah, the question I'm mostly interested in is whether one could still say, well, this is a kind of position of a third, or not. So thank you very much.